The meeting of the Criminal Law Subcommittee will come to order. Clerk, please open the roll and we will take attendance. Members, please record your presence. Having a quorum, we shall proceed. As is typical, as for all of the audience, while their docket is listed in a certain order, we always, as a courtesy, take members who are not on the committee. And as I know that the bills are not that controversial, at least in the first one I'm going to start with, I'd like to go out of order and pick up on House Bill 2111, Herring.
Good afternoon, Madam Chair. Can you hear me?
Yes, okay. I can.
And members, HB 211 is a bill that comes as a recommendation from the Virginia Indigent Defense Commission. And Madam Chair, there are some line amendments.
Council, if you would report the amendments, please.
Madam Chair, on line 13, we need to strike the number 17 and insert the number 18. And then on line 28, after the word commission, we need to insert the words or his designee. This was the original intent of the bill, and it makes it in line with the Senate version.
Typical. Is there a motion on the amendment? Second? Any questions, comments? All those in favor say aye. Okay, as amended.
Thank you, Madam Chair. So background in the issue that we're trying to resolve is that the Virginia Criminal Sentencing Commission develops and implements and administers our sentencing guidelines in Virginia. The commission also conducts criminal justice research, and they perform analysis of the fiscal impact of criminal justice information. Currently, however, the commission does not accurately reflect the perspectives of indigent people. This bill will improve Virginia's sentencing policies by including the executive director of the Virginia Indigent Defense Commission and the Criminal Sentencing Commission. The commission protects the constitutional right to counsel for people who cannot afford to hire their own attorneys. It administers court-appointed counsel certification as well as provide training to all certified attorneys to improve criminal defense representation to indigent citizens in Virginia who are unable to afford an attorney. The executive director, Madam Chair, by adding the executive director to the commission, we will benefit from a fuller range of insights resulting in guidelines that include indigent perspectives. Madam Chair, there is a disparity in sentencing. For example, in Virginia, black males receive sentences that are 13.4% longer than white males, and Hispanic males receive sentences 11.2% longer than white males. Research has highlighted these disparities. Courts impose a prison-only sentence in 89.8% of all cases. Conversely, a sentence of probation only was imposed in 5.9% of cases. Black males receive lengths of incarceration 4.7% longer, and Hispanic males 1.9% longer. So, Madam Chair, the bill is simple. We just basically need somebody from the Indigent Defense Commission on the Sentencing Commission.
Thank you. Are there any questions of the patron of counsel? Is there anyone here to speak for the bill?
Yes, Madam Chair.
I'm sorry. Delegate Batten.
Sorry, I have a question of the patron, please. I'm just curious, do the Commonwealth's attorneys also have a seat on there as well for balance?
Yes, Madam Chair, I believe that they do. Commonwealth attorneys.
If you could come forward.
I may defer to our expert here.
And identify yourself.
Good afternoon. Maria Jankowski. I'm the Executive Director at the Virginia Indigent Defense Commission. Chairman Watts, Delegate Batten, the Attorney General is represented on the Sentencing Commission, and the Attorney General handles all criminal appeals.
Thank you. Are there any further questions? If not, since you had indicated you wanted to speak for the bill, would you like to proceed with your statement?
Thank you, Chairman Watts. Members of the committee, I won't belabor this. This was a commission-approved bill. It was a unanimously approved bill by our commission. In addition to everything that Delegate Herring's saying, there is actually not even any criminal defense voice on the Sentencing Commission. So it's not just indigent defense. There's no criminal defense representation by code on the Sentencing Commission. We did a survey of all other states. The overwhelming majority of states that have sentencing commissions have a statutorily mandated defense representation on their sentencing commissions. In some instances, there's a couple of them. In many, many, many instances, it's the public defender or the public defender commission or indigent defense commission. This is Alabama, Arkansas. I mean, it's a cross-section of all types of states. So I think this is nationally the norm. There has not been defense representation for substantial chunks of time in the past, and there currently is no defense representation. So I ask you to support the bill. Thank you.
Is there anyone else speaking for the bill? Anyone speaking against the bill? Delegate Herring, you have the final word before we act.
Oh, thank you. Apologize for that mistake. That's why I'm glad Ms. Jankowski was here. And I just ask you to support the bill.
Thank you. Motion is in order.
I'd like to move to report.
Second.
As amended.
Move to report as amended.
Are any discussion on the motion? Clerk, please open the roll. We recommend that HB 2111 be reported from full committee with amendment by a vote of 6-0.
Right. Thank you, Madam Chair and committee. Thank you.
Thank you. Delegate Jones, you have two bills that deal with fines and fees.
Yes, ma'am, Madam Chair. Thank you for
Which one
this
would
opportunity.
you like first?
I will do fines and fees. HB 1665. It was a bill we introduced last year. It passed the House and Senate and was just vetoed by the governor for one basic stipulation of wanting to charge individuals $10 for each time they requested a copy. What this bill does, Madam Chair, it just simply seeks to provide an itemized statement. The one thing that we can get when we pay an American Express bill or any bill, even at a restaurant, we can find out down to the penny what we have purchased. And we just want individuals who are trying to get their lives back on track to be able to do the same thing and have that itemized statement provided by the court system.
Thank you. Are there any questions of the patron? Counsel, is there anything that we need to be aware of? Okay. Is there, again, this does not involve any fiscal impact?
No, ma'am.
Thank you. Is there anyone here speaking for 1665?
Thank you, Madam Chair. I'm Michael Sass.
As many as we do, total testimony will be limited to 10 minutes. You all split it as you wish. Thank you.
Thank you, Madam Chair. I am Michael Sizemore, the Advocacy Manager for SARA of Virginia, and that's the Substance Abuse, Addiction, and Recovery Alliance, and we're here just to fully support the bill and its passage. Thank you.
Thank you.
Thank you, Madam Chair, members of the committee. Maisie Osteen from the Legal Aid Justice Center, and we very much support Delegate Jones bringing this back and thank him for that, and appreciate Delegate Cherry for chief co-patroning the bill. In my capacity at LAJC, I represent a lot of people who are dealing with court debt issues, and this bill is just a common sense bill that allows them to know what's going on and then set a plan for addressing it. The one thing I want to highlight to you all is the Code of Virginia requires that costs and payments get paid to restitution first, but sometimes because humans are involved, right, that cost might go, or that payment might go on to court costs rather than restitution. These itemized bills really allow people to know where their payments are going and take ownership in the restitution payments as well to ensure that it's going to the right bucket of payment. So that's one of the main reasons we support this bill, and I know that you'll hear from a lot of other great folks who are talking about how they've experienced court debt too. Thank you.
Thank you.
Thank you, Chair Watts. Apologize for the unorthodox nature of this. The man whose words I'm about to give you are,
Name, please.
my name is Mike Berryman, I'm sorry, thank you, Chair. The man whose words I'm about to give you could not be here because his probation officer told him testifying in this venue could return him to prison. And he didn't feel the risk to be worthy. However, we do feel his words to be more than worthy. So with your grace, I will read what he has prepared for you all today. I was released from St. Bride's Correctional Center in April of 24. Like many, I was put on probation and assigned a probation officer. I had no savings account, no income, and no job. Fortunately, I had been admitted to a transition house and had a network of people to help me. However, one of the first requirements of our probation was that I pay off all of my court fines. So I went to the courthouse to find out how much I owed. I was given 2 invoices. One was for $613 and the other for $5,000. I was in shock. Fortunately, I did have a network of returning citizens who advised me to request an itemized list of these charges. But when I asked the court clerk for the itemized list, I got nothing back but blank stares. I patiently but assertively persisted in my request. Eventually, someone from the back office came forward and offered to help me. After reviewing my account, it was discovered that the second invoice, the one for $5,000, had been generated in error. Excuse me. Okay. Eventually, after reviewing this, the second invoice for $5,000 was dismissed. I did not even owe that money. Imagine my relief. I was fortunate. But think for a minute of the many, many returning citizens who are not that fortunate. The ones who don't have transportation or a network or even know how to ask for a detailed invoice. For men and women just coming out, just starting, $5,000 is a lot of money. That could be 6 months of rent, a used car, or a year's worth of groceries. Research estimates that 10% of our returning citizens are overcharged for their court fines. This is why mandatory transparency is so vital, and I hope you support this bill, as I do. Thank you.
Thank you.
Good afternoon. Thank you, Chair Watts.
Your name?
My name is Gerard Palms, and I recently did 13 and a half years. When I came home, I had what I owed the courts. I went to 3 different localities to make sure that I didn't owe them, or if I did owe them, I could take care of it so I can be a productive citizen of society. Well, the court was overcharging me based off of what they had. When I got to the root of what I actually owed, I had to go through a law firm and through DMV. If I would have known, I set up a payment plan with one jurisdiction, and when I set that payment plan up, I'm paying money to a jurisdiction that I don't owe money to. I actually owed money to the law firm. So it took 5 months for me to get that together. Hopefully that helps because it's really happened to me. So.
Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Cammie Blatt, and I'm a policy analyst at the Commonwealth Institute. We support HB 1665 because it brings transparency to court costs, helping individuals better understand and manage their financial obligations. Currently, many individuals only receive a total amount owed with no breakdown of fines, fees, or restitution. This bill ensures individuals can easily access a detailed statement of their court costs. HB 1665 will reduce confusion, help individuals track payments more effectively, create a clearer, more transparent process for managing court costs, benefiting both the public and the court system. For these and previously mentioned reasons, we ask that you support HB 1665.
Thank you.
Good afternoon, Chair Watts. Good afternoon, everyone else. My name is Abby Kern. I am in support of House Bill 1665, and here's how not knowing what I owed for court costs affected me. I would like to, I'm so sorry. Not knowing what I owed in court costs in multiple counties, and it wasn't until I was being garnished and contacted my employer's HR department that I got an amount of what I owed. I had to contact multiple other entities to be able to get an amount of what I owed for other counties, but no explanation of what the numbers meant and what I owed exactly for what. We don't leave the store without a receipt of what we paid for, so why should our court costs be anything different? Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. Dominic Martin, New Virginia Majority, and for the reasons stated, we support the bill.
Thank you.
Greetings, I'm Fatima Moahed with the Humanization Project. Chair Watts, we support this bill. We've dealt with many returning citizens who have been impacted by these non-transparency in fines and fees. And an audit of the Virginia Circuit and District Courts in 2019 found 1 in 10 of the sample cases have been overcharged, totaling $43,000 in extra charges against 115 people. These people want to be productive citizens. They want to be able to pay these bills so they can move on with their lives. So for these reasons and those of everyone else stating, we support the bill. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the subcommittee. Emily King with the Fines and Fees Justice Center. We're a national organization that provides technical support to states across the country working on fines and fees reform. And for the reasons stated, we also support this bill. Thank you.
Good afternoon, Brad Haywood on behalf of Justice Forward Virginia. We support the bill.
Thank you. Is there anyone speaking in opposition to the bill? Please come forward. Seeing no one online, I also have Allison Chafin. She had to drop off. So now we are back to, are there any questions of the patron or of counsel based on the testimony? Delegate Batten.
Thank you, Madam Chair. Question, I'm not sure if it's for the patron or for someone else in the room. I believe we had a similar bill to this last year, and we heard from the clerks, the court clerks. I was just wondering if there was anyone here to say whether or not they're supportive of this?
I don't want to necessarily speak on the behalf, but I will repeat what they shared with me, that they had no issue with it last year nor this year.
Thank you. Any further questions? Yes, Delegate Cousins.
Thank you, Chair Watts. I just have a question about, because it looks like there is a fiscal impact of a little over $83,000, but OES indicated that they might be able to absorb that cost. So just a little unclear on whether we need to refer it to appropriations or not.
I have not received word about referring it to appropriations.
I think someone from OES
We will
is
check
here.
before full committee should it be reported.
Okay. And it looks like we have someone from OES in the back.
Yes, Office of the Supreme Court, Secretary of the Supreme Court. Executive Secretary of the Supreme Court.
It's a long time. Madam Chair, members of the committee, yes, we did file a fiscal impact. DPB indicated they thought we might be able to absorb the costs. The problem is if there's like 5 to 10 bills of smaller costs, then it becomes an issue. House Appropriations is aware of that, and so they're aware that there are several bills with smaller fiscal impacts. Each one on their own we may be able to absorb, but altogether may be an issue. So House Appropriations is aware of that.
All right. And again, we will have time before full committee when we have other bills perhaps. Yes, Delegate Hernandez.
Thank you, Madam Chair. This is a question I think for you, for OES. In the event where someone owes court fines and fees in different jurisdictions, are they able to go to one stop to get a full list everywhere, or do they have to visit each locality separately?
Each locality.
Okay. Thank you.
Any further questions? If not, Delegate Jones, you have the final word on the bill.
Thank you very much, Madam Chair. The only thing I just wish to state again is that Delegate Mike Cherry has signed on to be a chief co on this, and so it's something that he believes in, something we both believe in, and just assisting men and women to just get back on their feet by simply knowing what they owe.
Thank you, Delegate Jones.
Thank you.
Motion is in order. It's been moved and seconded that we recommend reporting HB 1665. Any discussion? If not, clerk, please open the roll. Member, cast your vote. The subcommittee recommends that HB 1665 be reported by a vote of 7-1. And Delegate Jones, you have a second.
Thank you, Madam Chair. HB 1661, I believe there's an amendment that was submitted this morning.
Madam Chair and Delegate Jones, if you wouldn't mind just explaining the purpose of the bill, but then we'll get into the meat of what the words are going to say.
Indeed. Thank you. Basic summary of this bill, we just seek to have a standardized minimum payment for individuals that have court-ordered fines and fees across all courts in Virginia, addressing the lack of a uniform payment structure. One locality could charge a particular amount, another locality could do something different. And we just want to have and establish a universal payment for individuals entering into payment plans, ensuring that all defendants have access to fair and consistent payment options. And so that's basically what it does. There was a gentleman that came out, there was a report in the Richmond media, that individual owed $140,000 in restitution. That's a hefty law school degree. And to try and pay that back when you're just coming and returning home, it's almost impossible to do that. And so we want to ensure that men and women aren't defeated at the onset, but they're able to have something that, and again, this is not about, Madam Chair, individuals shirking their responsibilities. They just want to be able to manage those responsibilities in a fiscally safe and prudent manner. Thank you.
Any questions of the patron or of council? Are there any comments on the bill? Delegate Williams.
A question for
I'm sorry, we are using request to speak. You're better than I am. Thank you.
Just for the patron. Have you found that $25 a month is the going rate for courts across Virginia? Just from personal experience, it's been about $50 a month.
Madam Chair, I could not hear his question. I apologize.
I'll repeat it.
Thank you. I couldn't hear you.
So did you find that $25 was like the average across the state? It's my experience to see $50 a month. So I was just curious where you found, how you came up with $25 a month.
Madam Chair, what I would respond in answer to the delegate is that we're looking for for a sum in which individuals who show that they are not financially able to pay anything above that, if they have the financials to show that would be the amount assessed. If they're able to do more than that, then that's fine. But again, we're just at least having one consistent minimum.
Did you have a follow-up, Delegate Williams?
Yeah, I saw it.
It is. That answered my question. Did the council answer the question? I was just making sure that the public also understood your concern.
Yeah, I'm good.
All right.
Okay, all right.
Thank you, Madam Chair.
All right. Is there anyone here speaking for HB 1661? And again, it'll be a total of 10 minutes, please.
Madam Chair, I have my request to speak on.
Delegate Batten.
I have a question, I guess, for the patron. Sorry, I had my...
If you all could hold, because I also need to recognize another member of the committee before we take testimony. Thank you. Actually, I don't, but if you would.
I'm sorry.
So I have, I guess, two questions for the patron. Number one, what is the current median household income in Virginia?
What is a current median household?
Yes, because the bill says that it will, you're going to look at it every single year to determine the median household income. So I'm just curious if you have that number.
Madam Chair, I think I can help. In the new proposed language, that part actually does come out.
Thank you.
Okay.
Although it's approximately $42,000.
Thank you.
Thank you.
Okay, see no one else in request to speak. Now we will take testimony again, a total of 10 minutes for those speaking for.
Brad Haywood on behalf of Justice Forward Virginia. This bill actually reflects what is the law according to the Constitution, or the Supreme Court of the United States in Bearden versus Georgia. They stated that government can't run debtors' prisons, and if somebody can't pay, they can't be put in jail because they can't pay. Unfortunately, courts throughout Virginia and judges throughout Virginia don't understand that. Within the past 6 months, I've had a judge tell a woman with intellectual disabilities who was making about $9,000 a month as a part-time cashier at a supermarket that she had to pay $200 a month in her court costs. And I've also had judges order people who receive disability checks or welfare to take money out of that in order to pay their court costs. So this adds a lot of clarity and is more consistent with the Constitution. Thank you.
Madam Chair, Fatima Muwahed with the Humanization Project. Virginia already applies a standard minimum $25 per month payment on DMV debts. So this just is in line with that, and the current variability punishes people differently depending on where they lived at the time they got in trouble, creating unequal opportunities for successful reentry, which is really what this is all about. While some jurisdictions already successfully employ the recommended $25 minimum, Nelson and Staunton County to be exact, other areas have reduced payment plans that can still amount to hundreds of even thousands per month. So of the 44 jurisdictions with minimum amounts listed, 41% had minimum payment options of at least $100 a month. I make just over the medium, and that would be very difficult for me, and I'm not a returning citizen. So for that, we support the bill. Thank you.
Thank you.
Madam Chair, Michael Sizemore, Advocacy Manager for Sarah of Virginia. We endorse and fully support this bill and its passage. Thank you.
Thank you.
Madam Chair Watts, my name is Mike Berryman, and I support this bill. As a returning citizen, having completed almost 20 years of incarceration myself, I restart my life with no family support and do so with $35,000 in court fines and fees standing over my head. I'm here because I'm afraid I can do everything right and still go back to prison because I can't pay enough. I'm proud of who I am. I've started a small business. I've studied and completed the test to become an insurance salesman in the state of Virginia, which you have to be accredited for. However, I'm afraid that I'm being sent back. I could be sent back to prison because I simply can't pay enough, quick enough on my fines and fees. I might not have enough to pay, so it could complicate any number of things. It's like having a car payment and not having the ability to drive it. It's just sitting over your head, something to loom. This makes it much more difficult to move forward. I hope that you can enact this minimum court pay that I, myself, and many like me can move forward constructively. Thank you.
Madam Chair, my name is Gerard Palms, and I support this bill. Initially, when I was released from prison, I set up a payment plan with the court system at a minimum of $50 because I knew that I could possibly afford $50 a month. This is an obligation. 3 months afterwards, as I'm still paying on this, I go to the DMV to get my license, and when I go to get my license, they're telling me that I'm paying to the wrong person. When I find out who I need to pay to, they say, okay, you can pay us, the locality, they say you can pay us, you can set up a payment plan, but you need to put $1,000 down and you need to pay $100 a month. So now I have $150 a month, but the difference between me having to put $50 here and $1,000 there in the middle of transitioning jobs, because as a returning citizen that's trying to be as productive as possible, I'm trying to get the best job as possible with transferable skills that I learned in prison. This is why I support this bill.
Madam Chair and members of the committee, my name is Cammie Blatt with the Commonwealth Institute, and we strongly support HB 1661. The ability to afford minimum payments toward court debt should not depend on your zip code. Right now, Virginia's court jurisdictions operate under inconsistent payment plans, with some requiring as high as $100 or more per month, while others allow $25 to $50 per month. This inconsistency exacerbates disparities, especially in communities with large Black populations and those living below the poverty line, where courts impose more fines and fees compared to the size of the local population. The $25 minimum payment standard outlined in HB 1661 will create a fairer system, allowing individuals to manage their debt while prioritizing essential needs like housing and health care. For these reasons and previously mentioned reasons, we ask that you support HB 1661.
Hi, good afternoon, Madam Chair. My name is Karen Grant. I am in long-term recovery with over 3 years of continued sobriety. I also work at the Real Life Foundation in Richmond, Virginia as a project coordinator. I work in recovery and the addiction field. I'm taking steps to further my career and help others, and I am here in support of this bill. After serving time, we are still burdened by the weight of fines that hold us back from reintegrating into society. I, too, am in the re-entry process. When I first returned to work, my wages were immediately garnished. And despite 3 years of continued sobriety and making payments across 2 jurisdictions, I find myself constantly deciding where to allocate my limited resources. I understand accountability. I also recognize that I do owe my debt, but I believe that the current payment structures are not practical for those of us coming out of incarceration. Most times I have to decide which necessities I have to put to the side each month in order to pay this debt. On the other side of this, I work day to day for a recovery program, helping others recovering addicts and guiding them in their recovery journey. I do hear countless stories and obstacles in their recovery to move forward due to these fines and their structures. If we could implement payment plans that are better aligned with our specific circumstances, I believe we would see more success in paying off these fines. And at the same time, we would be better able to contribute to our society, to ourselves, our families, and therefore less consequences on all ends. Lowering these fines or adjusting the payments could help ease this re-entry process. Together, we could find a way to ensure that our efforts to rebuild our lives are supported, just as I support this bill. To establish a universal payment amount of $25 across all jurisdictions would be more practical and successful, and also set a qualifying threshold for Virginia medium income and even considering lowering costs for people who cannot meet these payments. Thank you for your time.
Thank you.
Madam Chair Watts. My name's Stephen Beckett. I'm a peer house leader at a recovery program, Real Life in Richmond. I was released from incarceration a little over 6 months ago. Right now, my biggest stress in life is my fines. I put 1/4 of my income towards my fines because I have fines and court costs out of 5 counties. 2 of them counties are under advisement, so I've had to put all my money to them to get those 2 counties off my record. But I have counties calling my probation officer asking about payments from the other counties right now, and I'm fear of violating and going back to jail with all the weight on my shoulders. I'm taking care of what I need to, but it's really stressful. I'm doing really good in my recovery. Everybody says they're proud of me. But I'll be proud of me when this weight's off my shoulders and I don't have the fear of going back to jail. Thank you for your time.
Thank you.
Good afternoon, Madam Chair. Good afternoon, everyone. I am Abby Kern. I've been in recovery for almost 4 years now, and upon release from incarceration, integration into society was a difficult process. While also being in early recovery, one of the hardest challenges I had to navigate was being garnished for court costs and fines. For counties I didn't even know I had court costs in, on top of paying $100 a month for a separate county's court costs. This affected not only my bank account, but my mental well-being. It became nearly impossible to be able to afford groceries and afford my living expenses. Thankfully, I resided in a very supportive recovery residence, and I had family able to support me. Having these challenges while also being in early recovery really tested my ability to change. It made me question if this was now my new life in recovery, constantly in a hole. While I completely understand the importance of paying our court fines, fees, and/or restitution, and that in fact we must take that accountability to pay it, making these costs more affordable will allow people like myself who are starting from nothing to be able to start a foundation for ourselves and pay back what we owe to ourselves and society. I know that this bill will generate a path for us to have long-term success. Thank you.
Since we have less than a half minute left, if you would each come forward, give us your name and whether or not you're speaking as an individual from your experience in paying such fines and costs.
Thank you, Madam Chair.
Just your name and how your
Amy
perspective.
Herron, and I support this bill because I've been impacted by this bill numerous times. Thank you.
Good afternoon, Madam Chair, members of the committee. Sean Winetta speaking on behalf of myself. I do support this bill because I am impacted by this.
Thank you.
Thank you. Maisie Osteen, Legal Aid Justice Center, and we support the bill.
Thank you.
Thank you. Dominique Martin, New Virginia Majority, will support the bill.
Thank you.
Emily King, Fines and Fees Justice Center. We also support this bill.
Thank you.
Monica Hutchinson, Rise for Youth, and we support this bill.
Thank you. Are there individuals in the room speaking against the bill? If you would come forward. I have online, she has also gone offline, so at this point we have no further testimony. Delegate Jones, do you have any questions of Delegate Jones hearing the testimony? I'm sorry?
Yeah.
I am not, Council, I understand we have line amendments.
Thank you, Madam Chair, members of the subcommittee. This will be a little winded, but looking at the original bill, there's some new language being added to subsection D. It's still, the language that we're going to change it to still keeps it in the same spirit of the bill with that $25, but as Council mentioned earlier, there's no more references to like universal payment and the median household income. This is why I do law, not money. So the language for subsection D, I will just read it in its entirety of how the section would look with the new language woven into the current statute. In determining the length of time to pay under a deferred, modified deferred, or installment payment agreement, the court shall take into account the defendant's financial resources and obligations, including any fines and costs owed by the defendant in any courts. If the defendant requests to enter into an installment agreement, the court shall offer installment payments of $25 per month. However, the defendant may choose to pay a higher amount. If the defendant indicates that he is unable to pay $25 per month, the court shall assess the defendant's ability to pay using a written financial statement on a form developed by the Executive Secretary of the Supreme Court, setting forth the defendant's financial resources and obligations, or conduct an oral examination of the defendant to determine his financial resources and obligations. The length of a payment agreement and the amount of the payments shall be reasonable in light of the defendant's financial resources and obligations and shall not be based solely on the amount of fines and costs. The court may offer a payment agreement combining an initial period during which no payment of fines and costs is required, followed by a period of installment payments. No court shall require the payment from any defendant who was previously determined to be indigent by the court pursuant to 19.2-159, except with respect to restitution.
As I understand, this was offered by the Office of the Executive Secretary of the Supreme Court?
That is correct, Madam Chair.
I will leave it up to the committee. Are you comfortable with moving forward on this amendment, or should we suspend until you have a copy in front of you? I am sorry, I need to. I'm not hearing no one. We will go forward then. Is there a motion on the amendment as read? And second, any discussion? And again, offered by the Office of the Executive Secretary of the Supreme Court as far as how this minimum payment protocol will be handled.
Did they have a motion?
We have a motion and a second.
What is it? What's the motion?
The motion is to accept the amendment. Okay. As a substitute. Yes. So the motion before us, hearing no discussion or questions, then and here are also copies of it, the motion is that we accept the substitute language as read. I'm going to suspend just a little bit, let you all read it. I'm going to say to the audience, since I have glanced at a copy here, I'm just going to use this prerogative of the chair to say many years ago, I was Secretary of Public Safety, and we did a lot in prison industries. And I still look for the day when we really go into reform of prison industries so that we have adequate compensation for work done. Giving an example that I was exposed to at that time, in the country of Israel, their prison industries, 1/3 of the money goes into a savings account, 1/3 of the money goes to the family, and 1/3 of the money either goes to the individual or to pay such fines and fees. The 1/3 that goes into an account means that the individual, upon release, has some resources for as they begin the rest of their lives. So I bring that forward. Obviously, it would take good, solid reform, but I think when I hear all of these stories about finding the resources to legitimately pay the fines and fees that are restitution, I have to share that with you. Now, we're back on business. The motion before you, that is before you, is there any questions now that you've seen the wording? We have a motion. It's been moved and seconded that we adopt a substitute for HB 1661. All those in favor say aye. Opposed? Okay, the bill is now before us as a substitute. Any further discussion or questions? Delegate Jones, you have the final word as patron.
Madam Chair, I just want to just thank everyone that just came down and shared their own personal stories, and that's not always the easiest thing to do in this type of setting. So I just wanted to commend all the men and women that came down to speak to the subcommittee today.
Thank you. Okay, Delegate Cousins has moved as substituted. Second? Second. Any further discussion? Clerk, please open the roll. Members, cast your vote. HB 1661, we are recommending report with substitute by a vote, I believe, of 7-1. Thank you very much, Delegate Jones. And now I'm going to go with Delegate McClure because we're still talking about fines and fees, and then for planning purposes, Delegate Hayes, followed by Delegate Henson.
Thank you, Madam Chair, members of the committee. I believe that there is some new language, friendly language from staff, so I'm happy to explain my bill or wait till the end, depending on what you wish.
Madam Chair, I can report the new language so the delegate knows exactly what she'll be presenting on. Looking at the statute, this would be suggested as a substitute to the statute 19.2, 303.4. There was a shall that was stricken to make a may, but that language will stay a shall. And 2 new sentences will be added at the end of that code section that read, however, no court shall enter a judgment of guilt solely for the failure to pay costs or other fees. A court shall dismiss the charge prior to payment of such costs or other fees if all other terms and conditions of the deferral are satisfied.
So again, I assume that this would be an amendment in the nature of a substitute. Thank you. Any question? Do I hear a motion to adopt the second? Now it's appropriate to ask any questions about the amendment nature of substitute in front of us. Any discussion? No. Then all those in favor of adopting the amendment in the nature of the substitute say aye. Opposed? Okay. Delegate McGilliard.
Thank you, Madam Chair, members of the committee. HB 1886 allows a circuit or district court that has deferred proceedings to impose costs upon the defendant, but prohibits the court from requiring such costs to be paid in full as a condition of for the dismissal of proceedings in a criminal case. And so Virginia courts do not impose costs on a person when their criminal case is dropped or dismissed, or when a person is acquitted of a charge, except for deferred dispositions. Deferred dispositions offer a person who is typically a first-time offender the opportunity to have a charge dismissed upon completion of certain conditions and terms set by the court. So, Madam Chair, the bill before you does 2 things. First, it removes the requirement that a court impose costs on a person who has successfully completed a deferred disposition. And then second, it makes clear that when a person has completed all of the terms and conditions set by the court, that the court cannot enter a conviction simply based on the fact that the person has not paid all of the court costs. And so in jurisdictions like Charlottesville and Albemarle, judges enter convictions in these cases where a person has completed all of the requirements except payment of court costs. And so this creates a 2-tiered system of justice. one for people who can afford to pay the cost, and then another for the folks who cannot. This is especially problematic when a young person is the defendant and the person is often dependent on parents to pay those costs. Just to be clear, the bill would not relieve anyone who receives that dismissal in a deferred case from having to pay the cost. It would just simply ensure that no one receives a conviction rather than a dismissal as a result of just owing the cost. So, Madam Chair, I hope it's the will of the committee or the subcommittee to vote in favor of HB 1886.
Thank you. Are there any questions of the patron?
Madam Chair.
Yes, Delegate Williams.
Thank you. Madam Chair, I'd ask that ask the patron. Court costs are usually, restitution are usually included in court costs, as the definition is. I see staff shaking their head.
So I believe, and staff can, I'm no attorney, but staff can correct me on this, but restitution would be part of the terms and conditions, and it's not the intent of the bill for cost to refer to that. So they first would have to meet those terms and conditions, which includes restitution, and costs usually include a fixed misdemeanor fee, a fixed felony fee, DNA sample fees, jail admittance fees, things like that. So I know I'm preaching to the choir, but did I do well, attorneys?
Good answer. Good answer.
Any further questions, Delegate Williams? Okay. You're going to sponsor her for taking the bar for that answer?
That was good answer.
Are there other questions of the patron or of council? Is there anyone in the room who is speaking for HB 1886? Please come forward.
Brad Haywood with
So
Justice.
once again, you have 10 minutes total.
Brad Haywood with Justice Forward, Virginia. I was the public defender's representative to the behavioral health docket in Arlington last year, and we had a graduation hearing for a really remarkable young man who had struggled with for many years with schizophrenia. He'd put in 2 years of hard work, almost every day, going to therapy groups, getting medication compliant, doing community service, every single thing the court and therapists asked of him. I stood before him with the judge at his graduation ceremony. Out in the lobby, there was cake, there were streamers, there were a podium set up for speeches, and the judge said, "Congratulations," and we were ready, everybody's ready to give him a round of applause, and then the clerk speaks up and says, "Judge, he owes $3,500 in court costs." Luckily, Judge O'Brien was able to pull some strings and get it down to $1,000. But in order to have him actually zero out his balance, we had to get Offender Aid and Restoration, a local nonprofit, to pay the rest. And had that not happened, I guarantee you that's the kind of stress that can cause somebody who's been in recovery, whose treatment is going to protect the safety of the community. It's going to jeopardize his recovery, and it would jeopardize the potential safety of the community. So this is actually a public safety bill as well. And so that's all. Thank you.
Thank you.
Thank you, Madam Chair, members of the committee. My name is Maisie Osteen. I'm from the Legal Aid Justice Center, and we support this bill. Last year, we were working with a young man out of Charlottesville who was charged with petty larceny. He had taken a phone, and that charge, the restitution associated with it was about $1,200. He'd never been charged before, never been in trouble, and this was a wild, wild wake-up call for him. And because of these great programs that we had, he was able to do, I think, 100 hours of community service. He was able to go into his group meetings. He was able to understand the impact it had on the complaining witness, and he'd complied with everything. He even paid a large amount of his restitution from his after-school job. But remaining that he learned about, because they said, "We're calling you back to court to close your case out on Thursday, it's Monday, you have $365 of court costs." He'd paid all of his minimum wage extra money already, and he didn't have it. But he'd been so compliant. We were able to, again, to partner with a nonprofit to get that remaining money. But that is crazy that that's the difference between a young man walking into the world without a criminal conviction after being compliant, doing all the things that we'd asked for him to do, and having a truly fresh start. So we ask that you also support this bill for those reasons. Thank you.
Thank you.
Good afternoon, Madam Chair and members of the committee. Cammie Blatt with the Commonwealth Institute. We support HB 1886 because it ensures individuals aren't penalized or denied case dismissal just because they can't afford to pay court costs up front. Under current law, individuals must pay all court costs before dismissal, which disproportionately harms those with limited financial means. HB 886 gives courts more discretion to implement deferred payment plans. For people struggling to make ends meet, this allows them a fair chance to fulfill their obligations. For these reasons and previously mentioned reasons, we ask that you support HB 1886.
Thank you.
Hello again, Madam Chair, members of the committee, Dominic Martin, NVM, and for the reasons previously stated, we support the bill.
Thank you.
Monica Hutchinson, Rise for Youth, and for the reasons previously mentioned, we support the bill. Thank you.
Thank you. Is there anyone speaking against HB 1886 in the room? If not, online we have a speaker for Mrs. Teresa Hepler. If you'd bring her online, and you have 2 minutes.
Thank you, Madam Chair and members of the committee. My name is Teresa Hepler. I am the Executive Director at Student Legal Services in Charlottesville. I represent a lot of college students, and I have seen a disparity in how students who have parents they can rely on to help them, and students who don't have parents who can rely on to help them, and how they deal with deferred dispositions. The clients that I have who don't have parents who can help them, they are very, very stressed. They are scrambling to find the funds. They're on a fixed budget, and it takes them longer to move on from their cases and get them expunged. Conviction should never, absolutely never be based on economic background, and for that reason, I'm asking for this committee to support the bill. Thank you.
Thank you. Seeing no other speakers, are there any further questions of the patron? You have a final word.
Thank you, Madam Chair, members of the committee. I just really appreciate the testimony from folks, and ask that you all help to address this disparity in our court system. Again, like I mentioned, there's a two-tiered justice system for folks, those who can pay and those who cannot, and this bill simply fixes that. So I really ask for your support on HB 1886.
Thank you. Committee? It's moved and seconded that HB 1886 be reported with substitute. Any discussion? Clerk, open the roll. I'm sorry, Delegate Williams, did you have?
My button was just on.
Okay, all right. Clerk, would you open the roll? Members, cast your vote. HB 1886, we recommend reporting with substitute by a vote of 7-1. Thank you.
Thank you, Madam Chair, members of the subcommittee.
And now, Delegate Hayes, thank you for your patience.
Thank you, Madam Chair, members of the committee. Madam Chair, members of the committee, you have before you House Bill 1642, and we do have some line amendments.
Madam Chair, this will be in the nature of a substitute once it is adopted. We're passing out copies to members of the committee on some suggested language from the staff, and I believe that Delegate Hayes finds these to be friendly. I'm just going to read it. There are some copies up here if anybody wants one. As used in this section, artificial intelligence-based tool means any software, systems, or algorithms, including machine learning models, predictive analytics, and decision support systems that analyze data and generate recommendations or predictions used to inform criminal justice decisions. Criminal justice purpose means any activity related to the pretrial detention or release, prosecution, adjudication, probation, parole, correctional supervision, or rehabilitation of criminal offenders. And in subsection B, notwithstanding any other provision of law, the recommendations or predictions provided by any artificial intelligence-based tool utilized for any criminal justice purpose shall not form the sole basis for any decision related to such criminal justice purpose. The results of an artificial intelligence-based tool may be used in making or informing a final decision. However, any such final criminal justice decision shall only be made by a human. And that would be the bill.
Are there any questions? You all have it before you. A motion is in order to adopt the substitute. It's been moved and seconded that we adopt the text before you that has just been read as a substitute. Any comments, questions? All those in favor say aye. Opposed? Okay, so the language before you, Delegate Hayes, your comments on what you're now looking at as your bill.
Thank you so much, Madam Chair, members of the committee. What the bill seeks to do is to assist us in society with handling and dealing with the many tools that are coming at us. We know that there are great benefits that artificial intelligence offers, but I guess in many cases it helps us with productivity, et cetera. But there are some concerns, and many times these are risks involved as well as biases that come with the development of these tools. Madam Chair, members of the committee, we just so happen to believe that when it comes to justice, it's important that we also have some checks and balances on these tools, and that judges and other decision makers who consider all of the relevant information about a defendant in order to make the most appropriate decisions regarding diversion, sentencing, and or release, that a human with that expertise is involved in that process. There are some states, Madam Chair, members of the committee, that are just grabbing these tools and using them for final disposition. And we just happen to believe that here in the Commonwealth, we need to get in front of that and make sure that human expertise is involved in those decisions.
Thank you. Are there any questions of the patron or of council? Those in the room who are in favor of HB 1642 as a substitute, would you please come forward? You have 2 minutes each, please.
Hello again, Madam Chair, members of the committee, Dominic Martin, New Virginia Majority. Just wanted to add that when I was a part of the working group working on the PSA risk assessment, evaluating whether that would be a way for Virginia to move forward, one of the top things that was mentioned was the fact that all the decisions still needed to be ran by humans, and that this was simply just a tool, a guide, some extra context for the experts in the room to consider. And so just given that, we appreciate the delegate for bringing the bill forward and support the bill. Thank you.
Thank you.
Monica Hutchinson, Rise for Youth. I agree with what New Virginia Majority just said. We thank the delegate for bringing this bill, and we ask you to pass it. Thank you.
Thank you. Is there anyone wishing to speak against the bill? If you would come forward. Seeing none, and I also see no one online. Are there any further questions after testimony of the patron, council? Hearing none, a motion, pardon? We have a 1 second request. As I was about to proceed, as I understand, should we recommend reporting, it would be referred then, re-referred to Uber Chair? Just report, okay. Thank you for letting this committee do its good work in the field of administration of justice. I appreciate that. But by the same token, and I'm prejudicing the vote, I do thank you for the leadership. You use the words getting ahead of what is definitely a very rapidly growing phenomenon. Having said all those words, before we have a motion before us, a motion is now in order to report as the substitute. It's been moved and seconded that we recommend reporting HB 1642 as substitute. No further discussion. Please open the roll. All those in favor, please cast your vote, please. close the roll. We recommend reporting HB 1642 with substitute unanimously by a vote. I think it was 7-0. Yeah.
Thank you, Madam Chair, members of the committee.
Thank you. Okay, Delegate Henson.
Good afternoon, Madam Chair, colleagues, Uber Chair. I do have 2 line amendments.
Yes, Madam Chair, members of the subcommittee, there are.
This is HB 1874. I'm sorry, I should have announced that.
For HB 1874, the first line amendment will be on line 51, introduced after 9.1-101. We're going to strike that and insert a semicolon. And on line 52, after the word officer, we're going to insert a semicolon with the clause and is in good standing with no pending investigations or disciplinary actions. These line amendments will match what the Senate counterpart did to this version yesterday or Monday.
Okay, are there any questions of the amendments as reported? A motion is in order.
Madam Chair, I speak to the.
It's moved and seconded. Speaking to the motion, the amendments before us.
With a question to staff.
Question, please.
Staff just said something. You said it matched something from yesterday. What did you just say?
Yes, Chair Watch, Delegate Williams, there's a Senate cognate to this bill that was heard in Senate courts, and these line amendments were made in that committee. I know we do not amend bills based on what other committees do, but this would be keeping it in line with what the Senate version looks like currently, if you would like.
Thank you. Any further comments, questions? Again, would you explain the bill now as amended?
Absolutely. As amended, House Bill 1874, a cognate of Senate Bill 781, provides that for a 4-year period, retired or former law enforcement officers have the right to petition the court to prohibit the publication of their personal information. And personal information, as defined by the code, includes home address, home telephone numbers, personal information, or personal email addresses. So the goal here is once a police officer does retire, that they do have the opportunity to petition the court to withhold their personal information from public record due to safety risk.
If I may, either of counsel or of you, Delegate Henson, I want to be clear. It's 4 years from the time of the petition being granted to redact the information. Correct. So it's not necessarily 4 years after retirement. Correct. Or leaving the force.
Correct.
Thank you. Are there further questions? Is there anyone in the room wishing to speak for HB 1874?
Good afternoon, Madam Chair. Bill Carrico with Virginia State Police. I'm like an old habit. I just keep showing up. This is a bill that we requested because we represent both active and retired troopers, and we have a lot of our guys that are currently working that qualify to petition the court that are working undercover on drug task force, on gang task force. And we found out from one who had retired that it doesn't continue after you retire. The former officer in good standing with no disciplinary actions was added to it in Senate courts because we do have officers who, for whatever reason, leave the force to find other positions because of the stress and have been shot at. Their families are in danger, that they actually leave because of the family situations. So this is the reason the language is there for officers in good standings with no disciplinary actions. I hope you'll support the bill.
Thank you. Is there anyone else wishing to speak for the bill? Anyone speaking against the bill as amended? Before I go further, clerk has asked whether or not we took a voice vote on the amendments. Just belts and suspenders. All those in favor of the amendments as reported, say aye. Aye. Opposed? Okay, now they're officially before us. Are there any other questions, concerns? If not, a motion is in order. Any discussion? Clerk, please open the roll. Cast your vote. HB 1874 with amendments is recommended reporting by a vote of 8-0. And again, Delegate Henson, thank you for your work on clarifying this bill. Appreciate it.
I learned a lot coming to criminal sub. Thank you.
Now, I believe I don't see any other patrons in the room because I think everybody else, everything else, Arnold. Arnold
and Subcommittee.
Oh, my apology. Of course. Yes, I'm sorry. If I may, just in alphabetical order, Arnold, HB 1858, Delegate Arnold.
Afternoon, Madam Chair, members of the committee. HB 1858 comes at the recommendation of the Virginia Criminal Justice Conference. It adds clarity to the statutory speedy trial statute by clarifying that ancillary misdemeanors that go up with a felony that's been certified after a preliminary hearing or waiver of the same, that speedy trial provision that applies to those felonies applies to the ancillary misdemeanors as well. And I'd welcome any questions the committee may have.
Thank you. Are there any questions of the patron? Council, any comments? Is there anyone in the room speaking for HB 1858? Anyone here speaking against? And no one is online? So, and I assume there's no questions of the patron. Any final word that you've thought of in the moment?
I just hope to be the will of the body to support the bill.
Okay, and again, this is the recommendation of the Virginia Criminal Justice Conference. A motion is in order.
Move to report.
Second.
It has been moved and seconded that we recommend reporting HB 1858. Any further discussion? Clerk, open the roll. Members, cast your vote. Delegate Arnold, thank you for that clean bill.
I thank the chair and the committee. Thank you.
Okay, now I hopefully, as I look at our docket, we have Obenshain, and the reason why I mentioned that is that Obenshain's bill also dealing with admissibility of evidence involving children will match up with Delegate Delaney's bill, so I'm glad to hear them both together. And thank you for your patience, Delegate Obenshain. HB 2010.
Thank you, Madam Chair, members of the committee. The purpose of this bill is to take a trauma-informed approach to allowing juvenile victims of serious crimes the opportunity to have their cases heard while also minimizing the risk of re-traumatization. It's estimated that 1 in 4 girls and 1 in 13 boys will experience child sexual abuse, and we know from research that child sexual abuse is a underreported and often unreported crime. Young children have developmental limitations that of processing and articulating traumatic experiences, and that's why this statute exists, to ensure that the brave young men and women who do have the courage to come forward and tell their stories of abuse are listened to, and that they have the opportunity to hold the offender accountable. We understand that children often delay reporting, and oftentimes those delays can be extensive for long periods of time. And oftentimes there are only partial reports in cases of child sexual abuse. Sometimes they don't even know initially that what was done to them was wrong, and so that can delay reporting as well. There are many causes for delayed reporting, and this bill raises the age at which a child's prior statements can be used in a prosecution for a specific set of crimes against children. It doesn't change in any way the safeguards for a defendant that exist that allow the court to examine those statements in a pretrial hearing and to rule on the admissibility of those statements at that hearing. So that what this bill would do would be to raise that age from 13 to 15. That would be the age of the child at the time of the trial. And 9 other states around the country currently have a similar law with a higher age threshold than Virginia currently has, and there's really been a trend across the country to raise that age to allow older, sort of mid-teen age children to be included within these types of statutes, and so that the Commonwealth has greater flexibility to hold offenders accountable for these types of crimes. And I'll just point to a recent Supreme Court of Virginia decision back on November 14th, 2024, Bista versus Commonwealth, dealing with this statute that I think demonstrates the need for this statute and how important it is. That case dealt with an autistic child victim who was 11 years old when the offenses occurred, and prior statements from a forensic interview were introduced at the preliminary hearing. The victim testified at the preliminary hearing, but then was found unavailable or unable to testify at the trial, and those prior statements were allowed to be introduced under this statute. That conviction was affirmed by the Court of Appeals, and then that decision was affirmed on a unanimous basis by the Virginia Supreme Court. And so I think it just demonstrates the importance of this statute and what we're trying to do here. And I would ask the members of the committee to support the victims of child sexual abuse and our efforts to hold offenders accountable. Thank you.
Thank you. I have several questions before opening to other members of the. So my first question, assuming you're a newer member, you have it by request. Normally that means sort of reluctantly I'm introducing this. Would you explain why it's you have introduced it by request?
Well, it's not reluctantly. I'll tell the chair it's not reluctantly at all. In fact, I very much agree with the purpose of the bill. The bill was brought to me by request of the Attorney General's office, and so it wasn't my own idea, and so I wanted to give credit where credit was due and not take credit for somebody else's idea. So.
Thank you for your modesty, but again, the protocol has typically been by request means that I understand that the issue needs to be discussed, and I'm carrying it, but I'm not necessarily that totally enthusiastic about it. So just FYI.
Thank you, Madam Chair. I appreciate that.
Now I have a couple of questions of counsel where I need education. So this bill is amending Title 19.2. Whereas the next bill will be amending Title 18.2. What's the difference? Because this only covers the victim. It doesn't cover witness, whereas 18.2 has children witnesses in it. If you could educate me at least.
Madam Chair, the big difference between Title 19.2 and Title 18.2 is 19.2 is the criminal procedure title and 18.2 is the substantive criminal law. Be honest, I had no idea why 18.2, 67.9 is placed in that. They both deal with rules of evidence and how trials are done. This is actually 19.268.3 is probably more properly in the right title under the criminal procedure than the other one is. So I wouldn't read anything into the different statute or different places where they were placed. 18.267.9 it goes with the other sexual offenses. It does include witnesses as well. This includes, it actually is any child, so it's a witness. Could be a witness, could be a victim. It just doesn't use the word other witness. As it says it says it is the alleged victim of the offense. I'm sorry, I got the two confused in my own head. It is the alleged victim of the offense. So this is more narrow because it does involve some pretty heavy constitutional rights that a criminal defendant has in their right to confrontation, and so it's a little bit more narrow when it comes to whether these statements would be admissible. And this is relatively new compared to the rest of this. This was inserted in the code in 2016.
Madam Chair, if I could just respond to that a little bit as well, is that Yeah, this is referred to as the tender years exception to the hearsay rule. And so as a hearsay exception, that's why it's in the criminal procedure
What I need clarification from, either from counsel or if you are prepared to do it, does the fact that this only deals with a child where an offense has been against the child, as opposed to a child who is a witness, and you have, does this override 18.2 where we allow children who are witness to a crime? And if we change 18.2, what does it do to this as far as the age is concerned?
This only deals with the prior statements of the victim, this particular statute. So it doesn't deal with prior statements of a witness. I can't say that I've had an opportunity to look at what the possible interplay would be between the two bills or if there would be any. But my bill only deals with prior statements of the victim themselves, not with any witnesses.
So it's only just a statement made whenever?
An out-of-court statement, yes. So, for example, the Bista case that was just decided, there were statements made to the victim's parents. There were statements made in a forensic interview that was outside of court. And so those were the type of statements that were admitted under this exception.
My final comment, and certainly if I'm mistaken, I would appreciate being corrected. It still causes me great concern that this is the child at the time of trial, because the offense happened a number of years ago. So that you are really limiting this is limited to much younger victims at the time of the offense. By the time it actually comes to trial, the child who, while you're trying to raise it and you're going in the right direction, the reality is that the actual crime happened some time ago.
Well, the crime really could have happened, I'm sorry, Madam Chair.
Way back.
The crime could have happened at any time, really. Sometimes, again, as I say, we know that there's often a delay in reporting when we have child victims. In the Bista case, I'll refer to, in that case, the child was 11 years old when the offenses occurred. The trial took place about a year and a half after that. So it wasn't that long of it wasn't years and years. It was, it was reported fairly quickly, but there were some statements that were made that because of the child's autistic condition needed to be introduced at the trial, and they wouldn't have been able to introduce those otherwise.
Thank you.
So,
are there questions of other members of the committee? I see none on the request to speak. Is there anyone in the rooms wishing to speak for HB 2010?
Yes. Thank you, Madam Chair. Members of the subcommittee, I'm Jeff Hayslip, Commonwealth's attorney for Fluvanna County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. We do support the bill for all the reasons that Delegate Obenchain spelled out, as far as the reasons that there are child victims that need those protections. This bill, as was stated, came online about 7 or 8 years ago. And this exception, this very limited exception to the hearsay rule, has been used sparingly, it's been used successfully, and it's been used fairly. There are safeguards for the constitutional protections. There's a hearing. In most cases, the victim actually does testify, but the earlier statements can also be let in. This is very different from the closed circuit case statute. So I would respectfully ask the court to sort of separate those out and consider them separately. So with that being said, we feel like this is a very reasonable raising of that limit. It does keep us well within the age range of the 40 other states that use this. So we would ask the committee to pass it through. We think it's a very good idea.
Thank you.
Good afternoon, Madam Chair.
Sure. Thank you.
Good afternoon, Madam Chair. Brandon Robleski, Senior Assistant Attorney General. The Attorney General does support the bill, and we thank Delegate Obenchain for bringing it. We're simply trying to move the age of admissibility of these statements from 8th grader to high school sophomore. We're not asking to change the rigorous vetting process that happens in the pretrial hearing. This can't happen without a hearing where multiple elements have to be checked off by the court to ensure the defendant has procedural due process. And the Supreme Court does hold that these hearings satisfy the Confrontation Clause. I think the main difference between Delegate Delaney's bill and this bill is in Delegate Delaney's bill, the victim is testifying, albeit via closed-circuit television. This allows the victim's prior statement, assuming it meets the reliability criteria, to be admitted, thus avoiding re-traumatization of the victim. So for those reasons, we hope it will be the will of the body to report the bill. Thank you.
Thank you.
Good afternoon, Madam Chair, members of the committee. Patrick McKenna, Virginia Coalition Against Human Trafficking, the coalition, for reasons previously stated, and some testimony that we presented on Delegate Delaney's bill, supports this bill.
Thank you. Is there anyone here speaking against the reporting of HB 2111?
Brad Haywood for Justice Forward, Virginia. I think as this committee knows in dealing with similar bills, it is important for the legislature to tread very lightly when dealing with the Sixth Amendment. The Sixth Amendment is one of the most robust criminal procedural rights. It incorporates the right to confrontation, and it is a critical safeguard to ensure that people aren't convicted erroneously. In fact, there are very few methods that a defendant has, tools that they have for ferreting out the truth of a witness who is lying. And actually, the Supreme Court of the United States and Virginia have recognized cross-examination as being really almost the one and only. And anytime that a statute starts to encroach on that or broadens the exceptions to the right to confrontation, it can be deeply problematic. 71% of false convictions include unreliable testimony, or testimony that's later found to be unreliable, and a disproportionate number of those false convictions that are based on unreliable testimony included the false testimony of a child, including 3 of the most recent exonerations in Virginia, and they were all actually child sex offenses where the children, they lied at trial, and then when they became adults or a little bit older children, they said, I lied, I was influenced by an adult to lie. So I haven't heard a reason yet why this bill should pass. What is the problem that is intended to be solved? The Basta case doesn't really shed much light on this. What that was about was a child who had, I think, autism and was deemed incompetent to testify, and because of the incompetency, because of their behavioral health disorder, then a hearsay exception, including those robust protections, could protect them. I'm unaware that anything that would say that 13 or 14-year-olds have a harder time telling the truth. This is one of these things that requires significantly more vetting, so we would oppose the bill.
Thank you. Is there anyone else speaking against 2111? Members of the committee, questions? Council? Okay. Delegate Obenchain, you have the final word on your bill.
Thank you, Madam Chair. I'll just say, with regard to the Bista case, again, that child was 12 when the trial occurred, and had the child been 1 year older when that trial occurred, under our current law, those statements would not have been allowed in, and somebody who committed and that person was convicted of rape, sodomy, and aggravated sexual battery, and those convictions may not have happened if that child was only 1 year older. And so I think that shows the necessity for this bill. So I thank the chair and I thank the committee.
Thank you. What's the committee's will?
Move to report.
Substitute motion.
It has been moved and seconded that, there are no amendments, that we... Substitute motion, yes.
Move to table.
Move to table. I'm sorry, I didn't catch the substitute. So it's been moved and seconded to report, and now we have Delegate Coulson, who has removed a substitute motion to table. Is there a second to the substitute motion? It's been seconded by Delegate Cousins. Discussion of the substitute motion to table.
There's no discussion.
Hearing No discussion of motion to table, thank you. I've got people all around me keeping me straight on this one. All those in favor of the substitute motion to table, please say aye. Aye. All those opposed? Do you want a recorded vote? Let's go for a recorded vote. Please open the roll on the substitute motion to table HB 1011. HB 2010, excuse me. The motion to table HB 2010 is approved by a vote of 5-3. The next bill before us then is now HB 1728, Delaney.
Thank you, Madam Chair and members of the committee. We have seen this bill before. We've seen a few iterations of this bill, and Madam Chair, I will let you know that I think before, if the committee wishes to act favorably today, we will likely see some ongoing amendments to this bill. But I will go ahead and introduce and remind the committee of the problem. I think we've had this discussion several years in a row. I hope this is the year that we're able to bring a more trauma-informed courtroom to young victims in Virginia. Currently, CCTV testimony is permissible in Virginia, but the current standard is incredibly difficult to meet. It's severe trauma, which if you look at the case law, that is an incredibly high standard to meet, as well as an incredibly damaging standard for a child. It does not align with what we would consider in modern times best practice for trauma-informed interactions. We know much more about trauma. We know much more about how trauma affects the brain. We know much more about how trauma affects a child. And we know much more about how trauma affects testimony and the accuracy of testimony. The current Virginia statute is so restrictive that it has been used successfully only once in my locality in Fairfax County. And in this case, a young girl was finally permitted to use CCTV after breaking down repeatedly in court while testifying against her dad, who had sexually assaulted her. The prosecutor's office did ultimately win the guilty conviction and a small measure of justice for her, but seeing this option kept from so many other children, really resulting in re-traumatization, has highlighted a problem that is very desperately needed to be fixed here in Virginia. So what this bill sets to do is to lower the standard of trauma. The bill before you has made several amendments that had been negotiated through conversations that we had with a variety of stakeholders on different sides of this issue, much through last session and continued, conversations over the summer. We have before you a bill that raises that lowers the standard of trauma from severe to moderate. But along with that, it does require that there be a court finding of clear and convincing evidence based on expert testimony. I will let the committee know that, after meeting most recently since this bill was docketed with stakeholders on this issue, there is still a little bit of room, I think, to further refine exactly how we want to get to, the correct solution for this. But I think that we are in a place where it is essential that we recognize the need for a more trauma-informed courtroom in Virginia, and in some method, lowering the standard from severe to at least moderate, I think is a step in the right direction, and finding the path to do that while we're both, protecting everyone's rights in the courtroom, as well as that child's rights, as well as, they're preserving their mental health and the integrity of their testimony. It would be the goal. What I want to make sure that we do is that in our pursuit to create a more trauma-informed courtroom by reducing the trauma standard, that we are not inadvertently raising the burden to pursue this method to a point where it would actually be used less. And that is part of the discussions that we're having with stakeholders right now to ensure that whichever proposal moves out of this body will be a trauma-informed approach that will lower the standard from severe, but to do it in such a way that will ensure that prosecutors will have more access to this provision than they currently feel that they're able to meet.
So with that explanation and the continuing work, do you feel that at this point you're ready to go forward, or would you rather have it go by in subcommittee as you continue to work it and get it into a better compromise position?
Madam Chair, that is the pleasure of the committee. I know we have committed to work with a number of stakeholders. I would be happy to come back to our committee next week with new language and some amendments if that is the pleasure of the committee. It's up to the chairs.
I think that this would be productive work to let it be go. We have time to take it to another committee meeting. Delegate, I don't have, Delegate Williams?
Question for the chair.
Question for the chair, absolutely.
Is the patron asking for more time?
Well, what I heard in the patron's testimony, I docketed it without having checked with her before, and I'm going to just use a phrase, being a good sport, she has presented the bill. But what I'm hearing as far as the work of this subcommittee, where substantive work should go on, it seems like what she has described, I think it would be better for this subcommittee to continue to be available to act on any further changes to deal with this issue.
So pass by.
That we just, I think that doesn't put it in a parliamentary jeopardy. Yes, we pass by for the day.
Madam Chair, I'm happy with the, I'm sorry.
Now, Delegate Colson.
Chair Watts, is it appropriate time to make a motion? I'd be happy. I would love to report it up. I'm in support, and I think it's ready to move up. So if I could make a motion to report, I'm happy with that today.
Do I hear a second?
Madam Chair.
Uber Chair.
Why don't we go ahead and hear the testimony, and I think let's hear where people are on the floor in opposition, and then we can make a decision. But I do commend the delegate for working so hard to get to this place. I think she's she's put in a lot of work into this bill, and so I think she's committed to working with different groups, different stakeholders, to see if there's a middle ground along the way.
Withdraw your motion, Delegate Colson.
Yeah, happy to withdraw the testimony. I just didn't want to pass it by for the day without saying.
We will pursue then, though, at this point, we will pursue to continue to hear the bill. My own observation will be, from my experience, I would just as soon that this subcommittee do the work rather than have it be done in Appropriations Committee where you don't have the same kind of background on some of these issues, so that to the degree that we can get it in the best possible shape before it is referred probably to Appropriations, I think we will serve the process. And so therefore, so we all know what we need to be thinking about and working on. If we can now hear testimony of those four reporting the bill before us, HB 1728.
Madam Chair, my understanding, this bill does not have a fiscal impact to it. I think it was sent to Appropriations in the past for different reasons, but let's wait and see if there's a letter. But meanwhile, let's keep the trains moving. And again,
there's a speaker letter.
There is a letter?
Yes.
Yes.
Okay. All right.
We can still do it and hold it and not hear it in full yet if we need to wait.
Okay. All right. So let's
Last year, it had, because of the number of capabilities that would require us the way it was shaped at that time, it was like a $500,000 impact. So that's the anticipation.
Well,
there'll be some impact.
We can act here if that's the will of the subcommittee and make our decision in full committee at that point.
But if we can hear testimony now so that we can shape how we might bring this in the best shape, best posture.
Good afternoon, Madam Chairwoman and members of the committee. I thank you for the opportunity to speak on House Bill 1728. My name is Gwen Cassidy, and I'm a member of the Virginia Coalition Against Human Trafficking, founder of nonprofit Managing Love, which focuses on human trafficking prevention, programming, and solutions, as well as a Harvard graduate student. I stand before you as a survivor of both child sex trafficking and adult labor trafficking. I stand before you urging you to vote in favor of this bill, urging you to consider the profound trauma inflicted on minors when they are forced to testify in open courtrooms, especially in the presence of their traffickers. Like 36% of trafficked persons, I was first trafficked by a family member, my mother, starting at the age of 4. Her friend and another primary childhood trafficker cultivated a special look that I knew to be the look that would precipitate the demise and death of my entire family if I said a single word about how my daily outings with my 68-year-old male nanny were to Prophet's Ice Cream Parlor, where very bad, nefarious crimes would happen to me and dozens of other young children in our small town. Testifying in such a difficult setting only re-traumatizes these children, causing further immense psychological harm and potentially jeopardizing their ability to provide truthful and comprehensive accounts of their exploitation, such as an intimidating and terrifying situation coupled with reliving the trauma due to the complicated neurobiological synaptic development during what is many times a fight or flight situation.
If you could please wrap up, thank you.
Okay. Sorry. I can only imagine being a 4-year-old again, a 9-year-old in my principal's safe office, a 10-year-old in my pediatrician's safe office, or what happened to me at age 14, and sitting in a court of law with my traffickers and getting that look. I cannot fathom how terrifying and nearly impossible it would be for there to ever be justice based on one look.
Thank you.
Thank you.
And again, since I should have asked everyone to come forward, we have 2 speakers at this point, so 2 minutes per speaker.
Sure. Good afternoon, Madam Chair and members of the committee. My name is Sanu Jang Cooper. I'm with the Action Alliance as their new policy director. We are in support of the concept of House Bill 1728, especially as it relates to child survivors who witness violence and when their testimony is helpful in holding abusers and harm doers accountable. The courtroom can be one of the most intimidating and re-traumatizing environments for survivors, especially children. These young survivors are often forced to relive their trauma in the presence of the person who harmed them. This re-traumatization can significantly impact their mental health and hinder their ability to provide clear and accurate testimony. Providing the option of CCTV testimony creates a safer and more trauma-informed process that centers the well-being of child survivors while still preserving their integrity of the judicial process. We are in support of a trauma-informed and least cumbersome process for survivors to be heard in the manner that protects their emotional and psychological safety. In my previous role as an executive director for a local program supporting the Hampton Roads area, we were directly involved in a case where a young child had to testify in front of his father, who severely harmed another family member. And we watched that process and how cumbersome it was for the prosecutors to just even get this option. So we are in support for it to be moved to a moderate process, and we thank you for your time and consideration.
Thank you. Is there anyone else in the room to testify for HB 1728? Anyone speaking against, please come forward. Again, 2 minutes.
Good afternoon. Again, Brad Haywood for Justice Forward Virginia. Concerns here are similar, and the bill has evolved, and it has, I think, it's closer to what comports with what the law is, according to the United States Supreme Court. It is true that closed-circuit television testimony is permitted. Maryland versus Craig was the case that decided this. However, it was a very closely decided case. It was a 5-4 opinion. Justice O'Connor writing for the majority, Justice Scalia writing for the dissent. And in that case, they decided that the Maryland law was comported with constitutional requirements, that it offered adequate opportunities for cross-examination, and while protecting or respecting the legitimate interest of the government in protecting children from unnecessary trauma. I think now we have a draft that comes pretty close to complying with Maryland versus Craig. There are numerous states that do have the moderate standard by clear and convincing evidence, but I don't know if there's any that include the last clause. This is line 33 into 34 after the last comma. So just so you know, the reason the Supreme Court permitted this in the first place the circumstances under which they permitted it were if the trauma caused the child not to be able to testify, really, essentially. If they really couldn't get the truth out of their mouth, or they were just speechless in a courtroom. Just being traumatized in the future was not deemed to be sufficient. There are states that do allow the fact of trauma alone, even if it didn't impact their ability to testify at trial, allow the fact of future trauma alone to justify closed-circuit television. But the standard is always, in those instances, serious or severe long-lasting adverse effects. Here, these are all those three things, reasonably communicating or rendering the child unavailable or causing long-lasting adverse effects. Those are all in the disjunctive. They're all ors. So any of those things is sufficient. And that last one is very broad. What is a long-lasting effect? Is it just something that every 2 years you think about it and you're like, oh, that day was horrible, I hated it? Or is it something where it's actually causing a really serious impact on your life and your behavioral health? And that's the part that I think requires more discussion. And really, it's so that this statute doesn't get overruled. Every single part of this statute in other states has been challenged on constitutional grounds. And you don't want to pass a statute that's going to come right back to you because the Supreme Court says this does not comport with the requirements according to the Supreme Court of the United States. So that's all. Thank you.
Thank you. Is there anyone here else wishing to testify against the bill? Delegate Delaney. So we're at the posture that we're at now.
Somebody on Zoom.
I'm sorry. Online we have, and we're on 1728. Forgive me. We have speaking for the bill, Kate Hanger. Kate, please proceed. 2 minutes.
Thank you, Madam Chair. Committee members, my name is Kate Hanger. I'm the Executive Director of the Virginia Victim Assistance Network. We are a statewide organization representing the rights and the needs of victims of crime in Virginia and the professionals who serve them. We strongly support this bill. This change will protect children who are already in a position of having to do the most horrendous thing they'll probably ever experience. We know that the majority of the time when a child is a victim of sexual assault or abuse, it was at the hands of a person that they were told they could trust and who would protect them. And the incredible distress of having to speak in front of a courtroom full of adults about something that was so confusing and overwhelming and distressing for them, it's cruel. I wish we didn't have to find a way to make it moderately distressing. I wish there was a way that it didn't have to be distressing at all. But for now, we're very happy that this has been pursued once again, and we are in absolute full support. Thank you.
Thank you. So we're at the posture where the decision would be to carry the bill forward. If I can restate the situation that we're in, that currently the law is based upon the child being traumatized to a degree that they can't communicate effectively to the jury and proceed and be part of the proceedings. The question before us is adding an additional standard that is a long-lasting adverse effects independent of anything else, just purely the welfare of the child being a consideration that the court will make that determination by clear and convincing evidence that there's long-lasting adverse effects. Is that a fair discussion of what you're trying to do is add that different standard that is not involved in the effectiveness of the communication, and it also puts the decision in the hands of the court by clear and convincing evidence?
So, Madam Chair, the current law, which I appreciate your leadership when it was written, I understand, it requires that either a child has persistent refusal to testify despite judicial requests, that they're are ineffective in their communication, or that there is a substantial likelihood that they would suffer from severe trauma. They would have to meet one of those criteria for the court for the judge to even be petitioned. That is not an automatic, you get to testify by CCTV. This is one of those criteria must be met in order for the attorney to even petition the judge to make the request for CCTV to be considered. I think of this, the most, kind of egregious failure of maintaining what we now understand would be a trauma-informed courtroom is the severe trauma. If you recall, several years ago, I introduced a bill that would have simply been more than de minimis, which would have gotten to Ms. Hanger's testimony of significantly reducing the level of trauma to what I would consider to be the most trauma-informed court environment. This would again be allowing the testimony to petition the court for the testimony to be done remotely, not to guarantee it, but to even ask the judge for that consideration. After lengthy negotiations and conversations, we did land on moderate being kind of the negotiated place where we landed, and I feel I feel strongly that is where we need to be. I think the debate that continues around this bill is whether or not some of those other provisions around expert testimony and, I think clear and convincing evidence is I believe, agreed upon. I think there's some more work to be done around the issue of, what the expert testimony applies to and whether or not cause the child to suffer long-lasting adverse effects is the right way to proceed with this bill. And so I think those are the areas where we still have a little bit more work to do. However, as many of you have either witnessed through this last year or some of you who've been on this committee even longer recall that, this is several years in the work and has been, strongly negotiated to give a lot from what I think many survivor and victim advocates would consider a very modern trauma-informed courtroom that truly takes into account the adverse effects of trauma, again, both on the brain, the child, and the quality of their testimony. But I think that we are moving this in the right direction so long as we maintain the moderate trauma. But again, Madam Chair, I think that there is perhaps a little bit more work that we can do to make sure that what we present to this committee is something that prosecutors believe that they will actually use and that it is not causing restrictions in other areas that would actually perhaps make this provision utilized less than it is now, while also maintaining, the integrity of what I think our survivor and victim advocates are seeking when it comes to a trauma-informed justice system.
Thank you. A motion would be in order. I want to make sure, as I just looked at my cheat sheet, that when we pass it by, it's not time certain for the day. It's passed by for the day. We have a number, not a lot, but we have more than one subcommittee ahead of us to get this right before we need to act on it.
Madam Chair, I'm not going to make a motion, but I just want to make a comment again to thank Delegate Delaney for working. This is 3 years, and we've had a full hearing, and this is probably, we've had several hearings on this bill. I think she's getting closer. My advice to, if it's the will of the subcommittee to vote the bill out to full committee, and I hope that they do, then I know she pledges to continue having these conversations. My advice to the delegate is don't make it worse when you come to full committee. Let's keep the progress going forward. And I think you're very, very close. So I want to thank the delegate and all the advocates, all the folks on both sides of this issue to try to thread this needle, and you deserve a lot of credit, delegate, for seeing this thing
Thank you, Mr. Chair.
close. Thank you.
And again, and in response, Mr. Overchair, I'm going to sort of hold this to my bosom and say that with exactly the same commitment that you make as Uber Chair, that we will get it out. I think where the work belongs is here in the subcommittee. To get it to a point, obviously, having your active participation on this subcommittee helps. So that's my proprietary grab. So again, as I read the parliamentary cheat sheet, when you pass it by for the day, that is not to a time certain, and a motion would be in order.
Is Carlson still made that motion? Carlson made that motion, I believe.
Carlson, do I have a second? You made the motion?
She made the motion before.
And was there a second? And so now the motion is, are we ready to vote?
To report to the full committee?
No, the motion is to pass.
That's the motion I made. I'm happy to withdraw the motion needed, but I'm confident in the delegates' ability to continue to work in good faith before it reports to full committee. And I'm personally comfortable with it as it stands, so that's my motion.
With due apologies, I'm having problems understanding what you said. You stand by the motion to report to full committee, having the work done in full committee by the discussion of the members there rather than confining the discussion to the members of this subcommittee.
Yes.
Second. Speaking to the motion, I really think that when you've got 22 people on the committee who are not familiar with this area of the law, that this subcommittee does a better job of looking at all of this. If the issue is that you don't want to leave it until the last day, I certainly, as a chair, commit that we've got to, and the patron commits that she's going to work out the best possible version of this so there is time for full committee to not be against the gun at the last meeting. That's what I would propose, and now it's time to voice vote on the motion.
Is it recorded?
Do you want me to withdraw?
You're on.
Madam Chair, I think that we can get a vote out today. I think that you might have an exception to that, but I do think that we do have that. We have our commitment to work. I think we're very close. I think if there are amendments to be offered in full committee, that they'll be very minor. I think we're very close to that. If it's going to be substantive, I don't think that's going to pass. So I do think that we're very close. Again, to emphasize, and I probably wouldn't be saying this, Madam Chair, if this weren't the third year that we've heard this bill, I think we're very close to where we are right now.
Thank you. Then the motion before us is to report to full committee. Is there further discussion?
And to
Recommend reporting?
No.
The speaker and also to refer then to appropriations. All those in favor, if there any further discussion?
Madam Chair.
Delegate Williams?
So we're going to move to, the motion is moved to report to the full committee. And at that time, the full committee could refer it to appropriations, says the speaker letter.
No, I don't believe so. We make the motion to report and refer to appropriations is the typical that our motion includes it, which is why I got the note that says, yeah, you do it. So again, the motion is to report and refer to appropriations. Is there further discussion on, and there's no amendments, so hearing no further, Carlson, you're, okay, got it. All right, Madam Clerk, if you open the roll, please. Please cast your vote. Okay, and any further votes? All those in the motion to report and refer to appropriation passes by a vote of 7-0. All right, now, I think, Delegate Williams, I think you are before us now, if you would go to the podium.
Thank you, Madam Chair.
Just a moment, if you'd suspend for a moment. Okay. Delegate Williams, we have HB 1556 before us.
Yes, ma'am. That's right. And so this bill is fairly simple in its language. It essentially it very simply says violations of criminal sexual assault or commercial sex trafficking when such crimes are committed against children. So that's the nature of the crime, the nature of the beast here. But what it does is expands the Attorney General's jurisdiction to prosecute across county lines within the state of the Commonwealth. Sometimes Commonwealth's attorneys are limited to their jurisdiction and have trouble prosecuting larger cases that cross across the state. I can think of an example of somebody sexually assaulting someone or commercially traffic them all up 95 and 85. And so if you have that going on, it's very difficult for each Commonwealth and each investigator to put an entire case together. And so we feel as though the Attorney General has a better resources and also a stronger jurisdictional ability. And this case would allow the Attorney General to prosecute those cases. So I'd ask.
Are there any questions of the patron or of counsel? Questions that I have, as I look at the language, you described it as only involving multi-jurisdictional as being the reason for the bill. But the language, as I read it, says that the Attorney General could prosecute any case.
That's accurate. That's accurate.
So this opens the door to any case.
It does, ma'am. Yes.
Thank you. Question of counsel? I have a question of counsel. So as I look at the list of what the authority is of the Attorney General in all of the cases, are there any of those cases that are violent criminal offenses?
Madam Chair, no, the only cases that are close, I guess, there are certain parts of the RICO statutes that could be considered violent criminal offenses, and the gangs, but those require the concurrence of the Commonwealth Attorney for the Attorney General to enter into those cases. This is up in the area of the statute where there is no requirement that the Commonwealth Attorney concur in the Attorney General's entry into the case, and therefore the Attorney General could initiate these prosecutions.
But when it comes to gangs, again, typically, as I know that body of the law, gangs involve oftentimes multi-jurisdictional, and while they may have involved criminal activity, defining what gang activity is, it's not the same victim issue that we have in the cases of children.
Madam Chair, that's true. And then also the gangs are limited to acts that occur on the grounds of state correctional facilities too. So it's even further limited when it comes to the gang, but it does involve the violence as you asked in the original question. But so it's further limited to having the concurrence of the Commonwealth Attorney, and it had to commit on the grounds of the state correctional facility.
Thank you. That's an important clarification. Are there other questions, concerns to be raised? Yes, Delegate Hernandez.
Thank you, Madam Chair. This question I think is for counsel, and just clarifying my understanding. So under the first paragraph A, that first clause, unless specifically requested by the governor to do so, the Attorney General shall have no authority. So that seems to suggest if there were such a case that for whatever reason warranted the Attorney General's involvement, notwithstanding the rest of the statute, that the governor could request the Attorney General's involvement. Is that right?
Madam Chair, Delegate Hernandez, that's correct. The governor could certainly request it in any single case, in any criminal prosecution in the Commonwealth if he or she felt so moved to do so.
Thank you.
Delegate Colson.
My apologies, Chair Watts. I had my speak button on the last go. I have nothing.
I'm trying to watch the board here, right? Are there other questions, concerns? If not, if we may move to those here who are speaking in favor of the bill, please come forward. So we have one speaker, 2 minutes, please. Two speakers, 2 minutes each.
Thank you, Madam Chair. Brandon Robleski on behalf of the Attorney General. The Attorney General supports the bill. This body has already seen fit to give the Attorney General original jurisdiction over child pornography cases, and this bill is simply a natural outgrowth of the substantive sex acts against minors that we sometimes discover when we are investigating child pornography cases. This bill is designed to just give those victims a more streamlined access to justice. The committee has seen this bill before, and I thank you for your consideration of it. Hope it will be the will of the body to report the bill. Thank you.
Thank you.
Good afternoon again, Madam Chair, members of the committee, Patrick McKenna, Virginia Association. I was going to bring it back for a second. I'm sorry. If you can't, we'll leave it at that. We support the passage of the bill. As the Attorney General noted, they already have the ability to prosecute child pornography. There's a huge correlation between human trafficking from minors and child pornography. It really is a common sense bill, and I think a welcome addition to the statute.
Madam Chair, members of the committee, Spencer Willett here on behalf of the Secretary of Public Safety and Homeland Security. The Secretary is very supportive of this legislation. Over the past 2 years, we've implemented multiple human trafficking initiatives through the Virginia State Police that have been working with local law enforcement. We believe that this will assist us in that effort, and would thank the delegate for bringing this up.
Further testimony in 4. 2 minutes, please.
Thank you, Chairwoman Watts. I'll keep it under a minute. I just want to say thank you all very much for your effort in this bill. As a founder of Managing Love and a survivor of child trafficking, it is instrumental to have more resources placed in this area, especially in the state of Virginia and places like Southwest Virginia. In Charlottesville, Albemarle County, we have a task force that we initiated less than a year ago, and these are now forming within the state of Virginia, but we need all the resources we can provide, especially to help the children of the Commonwealth of Virginia. Thank you.
Is there anyone in the room testifying against the bill? Please come forward. 2 minutes.
Good afternoon, Madam Chairperson. My name is Anton Bell. I'm the Commonwealth Attorney for the City of Hampton. I'm also the immediate past president of VACA, Virginia Association of Commonwealth Attorneys. And we do oppose this bill because this bill would basically usurp the authority of 120 elected Commonwealth attorneys who are better seated to be able to make these determinations as to which prosecutions should go forth and how the resources should be allocated. My particular jurisdiction is very well funded, as well as very active with multiple multi-task forces, including the Attorney General's office, including working with different grassroots organizations. I have worked with Patrick McKenna before. We are extremely very vigilant and very aggressive. And we have been elected by the localities to make sure that we will make sure that we take care of the individuals who are subject to these type of crimes. One of the cases that came up recently was the Cody case, which I'm sure Mr. Cardozo is very familiar with. I prosecuted that case personally. That took a lot of resources, but that was a task force that was put together to do that. And as such, when you create a bill that takes away the authority of the Commonwealth Attorney to make a decision as to concurring in that prosecution by the Attorney General's office, you are basically usurping the authority of the locality and the residents and the constituents who voted for that elected official. And for those reasons, we're asking this body to not report this bill. Thank you.
Thank you. Is there anyone else in the room wishing to testify against HB 1556? I see no one online. Final words?
Yes, Madam Chair. Thank you for hearing me on this argument. I did want to address, well, Southwest Virginia got invoked, so I appreciate that. But I did want to talk about, unless specifically requested by the governor to do so, it looks like the Attorney General already has the ability to fight child pornography and sexually explicit visual material. So I think we should expand this to, criminal sexual assault and commercial sex trafficking against minors. That's the goal of the bill.
Thank you. Our comments from the committee, before I ask for comments on the committee, I'm going to go ahead and make comments from the chair. I've been involved in this area for a long, long time, and certainly for the years that I worked with the CASA program, knowing very much, and in many different ways, the trauma of a child who is testifying and the issue, whether it's hearsay or whatever it may be, of that testimony keeping credibility. So in addition to associating myself with the authority that is the Attorney General already has to work with local prosecutors should there be a need that is multi-jurisdictional, and the fact that pornography can be prosecuted without having to have the victim, because you've got the evidence of the pornographic activity, I become very, very concerned about another party stepping in on a specific case, which is the way this is written, anything against a child that's a sexual offense, giving the Attorney General the ability to step in that case and begin questioning the child. It's not just the trauma that I am concerned about. It is the effective prosecution of that case in the testimony that may be contaminated without the kind of programs that need to be set up that are trauma-informed about how to draw credible testimony from a child who has been victimized, and that is not something that can automatically be done. With that, I simply do not see where, given what we have in the law, in the Attorney General's ability to go after pornography, in the ability of our local Commonwealth's attorneys to work cooperatively with and engage the Attorney General's office whenever they need to, as far as sexual offense and trafficking, I find this addition to be more of a concern than something that in fact moves forward what everyone in this room is concerned about, the horrendous crimes that we are dealing with in this case. So with that statement, a motion is in order. Yes, please. Delegate Cardoza.
Madam Chair, just a quick statement. First, I would love to applaud my Commonwealth attorney for his excellent work on the Cody case. However, I would say that I like to accept help where it's offered. The Commonwealth, the Attorney General's office has a great amount of resources that can be helpful. And as the patron has said, most of these cases, a lot of these cases, have to do with multiple jurisdictions. And this is just what the Attorney General's office is designed for when it's something that's multi-jurisdictional. And we're dealing kind of with an epidemic of human trafficking. And maybe in the future, once we have this handled, we can maybe return it back when it's lessened. But right now, we have a very huge problem with this. And I would love to see the Attorney General be able to attack it head on and really get a handle of it. So I will be supporting the bill.
Question, did your local Commonwealth attorney indicate that he did not have the authority to bring the Attorney General in to work with him?
He did not indicate that. In that case, he didn't need the Attorney General, but that was less of a human trafficking case and more of a familial murder case, so that would not have really applied.
Thank you. Further comment, questions? Motion, we operate on motion. It's been moved, seconded to PBI. That's debate is. Thank you. 2 minutes, no, I did. Recorded vote, 2 minutes per side. Since you are more informed on parliamentary procedure than obviously I am, do we start with pro or con?
He made the motion.
Okay, the motion is to table. Is there a second to the motion to table? Second. Okay, the motion before us is to table. Is there any, the table is, to lay on the table is not debatable. Therefore, if we will have a recorded vote, open the roll, members, cast your vote. Motion is to table. The motion to table passes by a vote of 5-3. And unless I'm wrong, I think we have gone through our docket. I thank you all for the robust committee meeting. Meeting is adjourned.